Serious personal injury accident, the victim may have two claims. The first claim would be for workers' compensation, and that comes about if the injured party was working at the time of the accident. But if there is yet another entity who was not the employer, who was negligent, then there is the possibility of a second claim, and that is a claim in tort for personal injury, and that goes through the court system as opposed to the Division of Industrial Accidents. Now, these two claims go on simultaneously, at least most often they do. And the workers' compensation people, in the form of the insurer, have the right to determine the medical treatment of the employee. That can create a conflict, and that can create problems for the worker, the injured worker. So let me just give a bit of background. The workers' compensation insurer will be subrogated to the right of the employee to make a claim for these tort benefits, these third-party benefits, as they're often referred to. So you would think if they're involved and invested in the claim against the third party, that there might be a coincidence or a mutuality of interests that they would have with the injured worker. Well, that would be a reasonable thought, but oftentimes their medical providers are in the business of making sure that the employee returns to work. And that could be an admirable and laudable goal, but it may not be reflective of the injured person's medical situation. So the result is that there would be many places in the file, in the workers' compensation file, all of which is discoverable in the tort action, where the medical reports and records are not all that favorable, where perhaps the medical provider is unfavorable to the injured worker, my client. Well, what do you do in that instance, especially where it's discoverable in the third-party action? The answer is you fight it. The answer is the client in a deposition can explain that he or she was told to come in for an exam and it turned out to be 5 minutes and the workers' comp doctor said this or said that or was very dismissive. So you explain it away, and as the employee's lawyer in the third-party action, in the tort action, I often hire my own experts to evaluate my client. Granted, they're not the treating physicians, at least in the early stage of the case. They could turn out to be treating physicians, but they will serve as a counterweight to that harsh and unfriendly medical view or medical report that would be in the workers' compensation file and used or attempted to be used to the detriment of the employee/client. So there are devices or sources that you as the lawyer or your lawyer can use to help combat a bad medical report from an unfair workers' compensation medical provider. Thank you.